Hello everyone, Namaste, warm greetings and a very good evening to all of you out there. Respected seniors, friends and well-wishers, I have the pleasure and the privilege to speak to you and interact with you on a very interesting, intriguing and fascinating aspect of law, which is not only important just to lawyers, but also to all the citizens, because what I'm going to talk today deals with a fundamental aspect of our fundamental right envisaged under the Constitution of India. For non-lawyer friends, I would just like to tell you that under the Constitution of India, we are protected and guaranteed certain fundamental rights under Articles 14 to 21, which are sacred and sacrosanct to every citizen of this country. Friends, these fundamental rights are fundamental to every citizen of India. Friends, in this background, I would just like to draw your attention to the preamble to our Constitution. The preamble is the basic document which lays down or which gives the introduction to the Constitution of India. According to the preamble, we are a sovereign, socialist, secular, democratic republic which secures to its citizens liberty of thought, faith, belief, worship, and expression. So this is what brings the preamble to the Constitution guarantees. Now, this preamble, friends, is translated in Article 19 insofar as freedom of thought and expression is concerned. The topic today touches upon this vital aspect where the famous journalist filed a couple of cases, rather two cases which I am going to discuss today before the Honorable Apex Court, that is the Supreme Court of India. The Supreme Court of India, in a very detailed judgment, in the times of COVID-19, gave, I can say, a very erudite, detailed and explanatory judgment on this fundamental right of freedom of speech and expression. Then, what is freedom of speech or what is freedom? Then, the expression freedom means the liberty given to an individual to act in the way and the manner that he wants without any fetters. Freedom is directed towards an action, and the freedom is guaranteed to us to accomplish that action. Friends, constitutions all over the world have guaranteed this freedom of speech and expression. However, when the Constitution was getting finalized, in the constitutional debate, that is in the early 1950s, this freedom was unfettered before the Constitution, of course, was declared and before the Constitution came into being. There were no restrictions on this freedom of speech. Anybody had the freedom to talk and express in the manner and whatever that he wanted to. Then, friends, this a follow-up on the debate, it was then unanimously decided that looking at all the constitutions in the world, the freedom cannot be unfettered. There has to be reasonable restrictions. Now, these reasonable restrictions are stipulated under Article 19(2). So, therefore, friends, the freedom of speech and expression which every individual would include journalists and all of us enjoy, is subject to reasonable restrictions under Article 19(2). Reasonable would mean something which is in the line of logic and which is replete with reason and common sense. It is not something which is arbitrary or whimsical. So such reasonable restrictions are those restrictions which are not arbitrary, excessive or unreasonable. These restrictions are contemplated under the Constitution of India under Article 19(2). Now, in this backdrop, friends, what happened was that on the 16th of April 2020, amidst this COVID pandemic situation, something very unfortunate happened. Friends, in a place called Palghar, which is outside the limits of Mumbai, two sadhus, came along with their driver, was passing over a particular village in Palghar in the night at around 9:30 p.m. Then a frenzied mob of hundreds of people gathered there. Policemen were present there, forest officials were present there, and these two sadhus and the car of these sadhus and their driver was brutally attacked. The sadhus were they were pulled and pushed out of the car, and the senior sadhu of 70 plus years of age, he rushed in absolute desperation, and seeing the policeman out there, he saw a ray of hope. He held the hand of the policeman, thinking that his life will now be saved. However, destiny had it otherwise. This policeman catches his hand and actually throws him to the violent mob to lead him to his destiny. Unfortunately, friends, the frenzied mob attacks the younger sadhu brutally. The attack is extremely brutal and it leads to killing of all the three persons in front of these policemen and forest officials who apparently did not take action. Of course, friends, as a result of these ghastly attacks, there were FIR. FIR was lodged the following day within the local limits where the incident happened. And thereafter, friends, after this FIR was lodged, Arnab Goswami, as you all know, on his show where he's the channel director of Republic TV English channel, where he holds this debate with Arnab at 9. On 21st April, he airs this debate, and for 21 seconds in this debate, he basically makes a reference to Mrs. Sonia Gandhi, the Congress Party president, and basically says that why is she silent? And despite such a ghastly event, there is the Gandhi family, which is the usual way in which Mr. Goswami talks. And he was filled with absolute remorse that why aren't people talking about this? Why aren't people curious about this? And in his style, he said, the nation wants to know the reason behind this silence. Interestingly, friends, after that, when he was returning to his home, he was attacked by two people he and his wife were attacked by two people who apparently, it was so revealed, belonged to the Congress Party. He files an FIR, and friends, all over the country for this particular 21-second clip aired on national television. There were FIRs filed all over the country at several places, including the state of Jammu and Kashmir. Friends, same incident, same event, and the FIR filed for what? Section anti-religious sentiments, inciting communal violence, conspiracy, defamation, and disturbing public peace and tranquility. These were basically, friends, in simple words, the sections under which the FIRs were filed or were registered. Then, friends, Arnab Goswami, obviously being hurt by this, aggrieved by this, and this is something which is a blot on his or questions his fundamental right to his speech and expression, which he does as a TV anchor. He approaches the Supreme Court under Article 32, which, friends, is one of the articles under which a writ is filed when your constitutional or your fundamental right is infringed. The Honorable Supreme Court, one of the finest judges today, and of course the finest lawyers representing Arnab Goswami, the state of Maharashtra, the Congress party, and others, all stalwarts. There were heated arguments made, and what was discussed is questions posed. As a journalist, does Arnab Goswami not have the right to freedom of speech and expression, which is guaranteed under Article 19 of the Constitution of India? Secondly, friends, the Honorable Supreme Court was also a little not happy with the fact that there were several FIRs filed all across the country for the same incidents and events. So, friends, what the Honorable Supreme Court did was, and I will make it as simple as possible, as the FIRs were filed at several places, in several states, for the same incident or event, the Honorable Supreme Court said this is not doable, or this is not what the law provides, because the FIR is not filed for different incidents, it is for the same incident. There is no difference at all. In fact, the language, the serial numbering, everything was identical, and therefore the Supreme Court said, what we will do is, the FIR which is filed in Nagpur, we will transfer it to Mumbai for investigation. And friends, Supreme Court gave kind of a relief to Mr. Goswami for a period of 3 weeks, which was further extended for a period of 3 weeks, as in to take recourse to the other remedies available to him in law. Friends, the discussion here was essentially on the ground that if Arnab Goswami has presented himself in a particular manner, which may not calibrate or which may not go well with the views, ideology, and with basically the way of thinking of several people out there, of politicians out there, is this reprisal, is this kind of filing several FIRs for the same incident tolerable? Is it justifiable in law? Then several judgments were discussed, and ultimately the Supreme Court came to a conclusion that so many FIRs arising out of the same event and same incident cannot be filed, and therefore only one FIR can be a subject matter of investigation for those alleged offences. Then protection was also given to Arnab Goswami because he and his wife were attacked as a kind of a onslaught or as a pursuant to this particular incident that happened. Now, friends, subsequently, the interesting development was that in another FIR, that is, you can say, besides, there were 14 FIRs on the same subject. One is alive, two are alive, one filed by against Goswami, one filed by Goswami for the attacks on him and his wife. A third FIR came to be filed against Mr. Goswami. Now, this FIR, friends, relates to an incident, a few days back, rather a few weeks back. Yesterday too, there was a mock gathering at Bandra. Now, this gathering, the mass gathering at Bandra, the accusation against Mr. Goswami was that he has incited communal violence and he had basically made this mob to come there and he is talking things which are communal and hurting the religious or sentiments of a particular community. On those lines, again, under similar sections 295A, etc. of the IPC, an FIR was launched against him. Then Arnab Goswami filed another petition before the High Court. I'm sorry, before the Supreme Court. Now, what does he say then? Before he filed his second petition, he was subjected to grueling investigation for a period of 12 and a half hours. Now, friends, in that grueling investigation, several appropriate, inappropriate, important, unimportant questions, even pertaining to who owns the channel, what is the shareholding in this channel, which are really not related to the incident, were asked. Then his CFO was also interrogated, and when the CFO of Republic was interrogated, two of the police were COVID positive. Now, friends, in the light of all this, friends, what happened was Mr. Goswami was obviously aggrieved by this, and therefore he appraised the Supreme Court of these details and wanted a transfer of investigation from the Mumbai police, which was investigating this, to the CBI. The reasons given were when allegations were made by Mr. Goswami against the Commissioner of Police that he is not getting a fair investigation because of these reasons, and therefore it should be transferred to an independent investigating agency. Now, friends, here is the proposition, and here is what I wish to make myself at least clear in this talk. There are two issues, friends, before the Honorable Supreme Court. One is the issue of protecting the fundamental right of freedom of speech and expression, which is an absolute right, absolute in the sense subject to reasonable restrictions. And the second is his demand to transfer this case from Mumbai to CBI for an independent, impartial investigation. Friends, these two are separate, distinct, independent issues. Friends, we need to understand that and appreciate that as far as the fundamental right issue is concerned, it has nothing to do with a person's prayer or request to the court to transfer the investigation. As far as, friends, his demand or his plea for fundamental rights was concerned, the Honorable Supreme Court completely agreed by citing several authorities, including the authorities where in similar such cases, the journalist freedom of expression was questioned. And in today's time, when Justice Chandrachud, he says, and I will read a couple of lines from the judgment. Article 32, as I was explaining to you all, constitutes a recognition of the constitutional duty entrusted to this court to protect fundamental rights. The exercise of journalistic freedom lies at the core of speech and expression, which is protected under Article 19(1)(a). The petitioner is a media journalist. Now, friends, kindly hear this. The airing of views on television shows which he hosts is in the exercise of his fundamental rights to speech and expression under 19(1)(a). India's freedom will rest safe as long as journalists can speak to power without being chilled by a threat of reprisal. This is the underlying operational, important decision of in these words, the Supreme Court has expressed its view you cannot sentence a journalist who is voicing his views in the manner. The manner may be inappropriate. Or some in the view of some people it may be appropriate, not inappropriate as such. He may be loud. He may be aggressive. However, as long as he is exercising his fundamental right of freedom of speech and he is questioning the power blocks, he cannot be chilled. There is a doctrine of chilling, means he cannot be told to keep quiet by using the fetter of a reasonable restriction and say that, look, Mr. Goswami, this is not fair. You are maligning someone's reputation and you don't have a right to criticize someone, or you don't have a right of dissent. Friends, right of dissent is basically a right to disagree. This is another facet of your fundamental right under Article 21, that is right to life. Friends, this and to live with dignity. So every person has the right to freedom of speech and equally a right of dissent, a right to criticize, a right to put his own views, a right to satire, and a right to criticism. That, friends, cannot be restricted in a democratic society like ours. Otherwise, our democracy will be threatened because these people, these journalists, friends, are purveyors. They are basically the people who give us the information on the basis of which the people come to know the affairs and how things are managed. And in a vibrant democracy like ours, every citizen has a right to know what is happening and has a right to basically also decide for himself as to whether whatever is happening is right, wrong, or whatever he wants to conclude is the person's choice. Then there is also a right or a choice given to you. Nowadays, today we are spoiled with choice. There are several channels out there. If you don't like Republic, you don't like some channels, you switch and you don't see that channel. So, therefore, the Supreme Court took all this into consideration and protected his right of freedom of speech and expression and said nothing doing all these FIRs against him for that particular 21-second incident we are quashing, except for one FIR which is being investigated. Now coming to the second aspect of the matter. The second aspect of the matter is he asked our senior counsel, Mr. Salve, one of the most brilliant and revered counsels of the country, vehemently made out a case of transfer of investigation. Justice Chandrachud asked him, Mr. Salve, are you maintaining this argument or do you want your client to pursue the remedies available in law? Which means that he had a right to approach the Bombay High Court for quashing the FIR. But Mr. Salve said no, the investigation is conducted in an extremely shoddy manner and therefore our client is under the threat of not having a fair, impartial and true investigation, which is a sine qua non of conducting a proper investigation in this country, and therefore the matter should be transferred to CBI. Then the Supreme Court, citing a number of decisions, including the decisions in the case where Justice Chandrachud himself dissented, in a case of this Bhima Korega offense, many lawyer audience would have heard about it, the Bhima Korega mob communal violence case. Again, the same issue came up, and it was decided by the Supreme Court that no one enjoys a right to choose the investigating agency, the right to ask the investigating agency as to how the investigation should go on, the manner in which the investigation should go on, the place of investigation, the time of investigation. All this is the prerogative of the investigating agency. Because if one interferes with the process of investigation and questions the power of the investigating agency, that would lead to a situation of chaos. As in and every person who is not happy with the investigation would not knock to the earth and say, I am not happy with this investigation. So what are the parameters? The parameters for transfer of investigation claims are that in the view of the court, it should be done in the rarest of rare circumstances. Now, rarest of rare circumstances depends upon the facts of the case. One of that circumstance is mala fide. If the police officer or the investigating agency is acting in a mala fide manner, lacks bona fide, then or the case has national and international ramifications, in those kind of situations, then a transfer of investigation is ordered. The Honorable Supreme Court came to a conclusion that this is not a case of that type. However, left all the remedies open in law to Mr. Goswami, including his legal remedy to challenge the FIR or to even quash the FIR before by approaching the Honorable Bombay High Court. Then what you all need to remember is, or the confusion that I see which is created is, that the petition filed, the second petition, that is for the transfer of investigation to CBI, was dismissed. So friends, a lot of people, particularly the non-lawyer community, and even many of them, perceive that Arnab Goswami lost in the Supreme Court. Friends, that is not correct. Mr. Goswami has absolutely won and succeeded on the aspect of protection of fundamental rights. That is precisely why the FIR was quashed, and only one FIR was allowed to be investigated. However, on the second different and distinct aspect, that is transfer of investigation, friends, the Supreme Court in its wisdom, following the law on the subject, said that this is not that exceptional a circumstance, particularly in a case where Arnab Goswami himself wanted the investigation to be transferred from Nagpur to Mumbai. It doesn't again make sense to transfer the investigation to the CBI. So friends, this is all what the Supreme Court said in the second petition. The Supreme Court has not even gone into the merits, has not even gone into the details of that particular charge sheet which was lodged against him for allegedly inciting communal violence in Bandra. So therefore, friends, it is not at all an open and shut case. Arnab Goswami very well has the rights today, even today, to pursue his remedies, to quash that FIR, and to take the necessary recourse available to him in law, except for the fact that he would have his investigation would be done by the local Mumbai police. Now, friends, having said all of this, friends, there is some perspective or there are some thoughts which are absolutely thought independent to me, which I would like to share. Friends, it is from a historian, from a famous historian I quote, questions you cannot answer are usually better for you than answers you cannot question. Friends, this was a part of the Honorable Supreme Court judgment when they were dealing with the fundamental right of freedom of speech and expression. Friends, in this context, I would also like to quote before you what Voltaire, the famous philosopher, said. I do not agree with a word you say, but I defend to death your right to say. This is the power of freedom of speech and expression. Friends, we must realize today these journalists are doing a phenomenal job. It's my personal view. People criticize it, saying media is conducting trials. Media trials should not be encouraged. Then that is a different subject. But if these journalists then were not giving us information, then there is always the toss of a coin. If heads you win, tails I lose. Every coin has two sides. And you may say that some of these journalists are overstepping their lines, are not conducting themselves in a proper manner. But at the end of the day, friends, the dissemination of information that is available to us in the boldest possible form and manner, not only by Mr. Goswami, of course, who leads the brigade, but also by people like Mr. Sudhir Chaudhary and Mr. Rajat Sharma. I feel that these people's voice ought not to be shut. These people's freedom of expression cannot be curtailed in a vibrant democracy like ours. This is the only manner or way in which a check can be put on the power lobby, on the politicians. Otherwise, friends, we would become a state of anarchy. It would be impossible for a democracy to function without these checks and balances. Friends, imagine a situation today where we had none of these channels. We would have got no information. We wouldn't know the COVID meter. We wouldn't know what is happening. We wouldn't know the policies of the government. We wouldn't be able to criticize the ruling party, or we wouldn't be able to know what good the opposition party is doing or what not good the opposition party is doing. Therefore, friends, one thing I would like to say, they are also, friends, with lot of thought I am saying this, equally COVID warriors, because they fearlessly, with threats to their life, are giving information in absolutely a frank manner. It may be exaggerated. Exaggerations, friends, are absolutely allowed. Fair comments are allowed. Fair criticism is a part legally allowed. So all that is within legal parameters. So as far as they are conducting themselves in accordance with law, as far as they are giving us information which is sometimes not available to common citizens like us, then I feel that every single day, 24/7, this continuous dissemination of information in a free and frank manner, may it be what the Vadra gang is doing, may it be what Yogi Adityanath is doing, then just imagine, we would have known nothing of this. So friends, in totality, I strongly believe that the Honorable Supreme Court has come out with an excellent decision, balancing both a person's fundamental right of freedom of speech and expression, which is extremely crucial for a man, for basically for journalists, whether they are on media or whether they are off media, because they are not going to speak things which the government wants. That is not impartial journalism. That will be tainted journalism. Therefore, what I respectfully would say in conclusion is that the Supreme Court has recognized this time and again. The Supreme Court has now, in fact, in 2020 January, in a decision, recently this decision was the daughter of Ghulam Nabi Azad. She in Kashmir said that her newspaper is prohibited from circulation, and also made complaints with regard to suspension of internet services. For the first time in January 2020, Justice Ramanna, a very senior judge, along with four other judges, said, and this is important, that the right to trade and commerce, the right to practice one's trade and profession on the internet will be equally a subject matter of one fundamental right under Article 19(1)(a). So whatever is being practiced or trade or commerce done on the internet now will be under the contours of a fundamental right under 19(1)(a), of course subject to reasonable restrictions under 19(2). Friends, in that case, it was established that it was not only the petitioner or the daughter of the politician whose newspapers were not allowed to be published, but there were several other newspapers who were in fact being published. So therefore, there was a little untruth the court found in this statement, and therefore the court concluded that the court was not inclined to interfere, however, saying that as far as the internet is concerned, the trade and commerce, the right to freedom of speech and expression would be a fundamental right to which would be applicable on the internet platforms, also subject to reasonable restriction. Then, finally, friends, I would like to conclude this by citing a few lines from a wonderful poetry which sums up whatever I have said or attempted to bring to drive home today. Friends, this is a poem by the famous Rudyard Kipling, and I would quote from that. And the name of the poem is "If." Only an extract, friends, I would read. If you can talk with the crowds and keep your virtue, if you can talk with the crowds and keep your virtue, or walk with the kings, nor lose the common touch, if neither foes nor loving friends can hurt you. If neither foes nor loving friends can hurt you, if all men count with you but none too much, if you can fill the unforgiving minute with 60 seconds worth of a distance run, yours is the earth and everything that's in it, and which is more, you will be a man, my son. So friends, if these people are allowed to talk with the crowd, keeping their virtue and bringing across their point, friends, they cannot be they cannot be curtailed, their freedom cannot be restricted. I conclude my talk, and I would invite your comments, comments, suggestions, or questions on our channel and on our email. Thank you very much. Jai Hind.